This case starts like any other. Until it doesn't. Mr. Aguilar stands accused of stealing a truck, tailgatias. You heard that Rita tailgatand, then turning around and selling it on Facebook Marketplace. But the story doesn't stop there. He's also tied to a hit and run, involving a metal gate, an Instagram acquaintance, and some seriously shady explanations. Is this man a career scammer or just in over his head? Stick around because things are about to get wild in this courtroom.
Here to stop and give information, striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take the Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DEMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
He was the seller on Facebook Market.
Okay, pause right here. We just hit a major legal turning point. The defendant admits to being the Facebook seller and says he bought the tailgate from a friend for $75. But that's not just flipping a used item. When you're reselling stolen property, intent becomes everything. The prosecution needs to prove that he knew it was stolen and now we hear he told the officer he did. That's a game changer. But here's the question. Would you believe this guy only met the friend through Instagram and had no clue? Let us know in the comments because that defense is shakier than his resale profit margins.
There's no information in the DEMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right? It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DEMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Failure to stop and give
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to move forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on that door?
Don't. I know that you are itching to say stuff. Don't.
Oh, no,
you
no,
have
sir.
the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So
Yes, sir.
just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
Do
Your
you
Honor.
understand?
Yes, Your Honor.
Your Honor.
Tell me what time of night was, do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Okay. I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger to my city. You understand me?
I understand.
Come on.
So here's where we land. Mr. Aguilar faces 2 separate charges, one for allegedly stealing and reselling a tailgate, and another for fleeing the scene of a property crash. The judge finds probable cause in both cases, throwing shade and stern warnings throughout. From a Facebook marketplace sting to a mystery Instagram acquaintance, this case blends digital breadcrumbs with old-school detective work. Whether it was ignorance or intentional, one thing's clear: the courtroom isn't buying what he's selling. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.